Experts offering graphic testimony in the Casey Anthony trial this week, and some of it leading to emotional outbursts in court from Casey and, in fact, her mother, Cindy. Prosecutors are laying out their forensic evidence, hoping to prove Casey not only killed her daughter, but also lied about it.
Do you have an opinion as to the manner of death in this case?
Yes.
What is that opinion?
Homicide. There is no child that should have duct tape on its face when it dies. There is no reason to put duct tape on the face after they die. Based on our experience, we've seen that in cases of homicide.
Let's bring in our legal panel. Vikki Ziegler is a civil attorney and an adjunct professor at Fordham University. Robert Schalk and Joey Jackson are both defense attorneys who used to serve as prosecutors. Welcome to all three of you. All right, the medical examiner testified that homicide is the manner of death, but nobody can prove the cause of death or the mechanism of death. Vikki, is that a problem for prosecutors?
Well, they don't need to actually prove the cause of death and in fact to get a conviction in this case, but certainly I think by offering the potential and confusion of how this child actually died, was it chloroform or was it suffocation based on the duct tape, I think jurors may be questioning that, and it may cause a problem for the prosecution ultimately, especially to get a conviction on the first-degree murder.
Hey, Robert, what about that? I mean, it seems as though prosecutors are doing more than they have to do. They are saying, we know the cause of death, suffocation. The murder weapon was the duct tape wrapped around the nose and mouth of little Kaylee. And yet, they cannot prove that. Admittedly, they cannot prove that. So are they going out on a limb here and actually, in a way, creating reasonable doubt for the benefit of the defendant?
Well, they're giving the jury an out. If the jury wants an out, they have it.
Well, why would you as a prosecutor ever do that? That's a mistake, isn't it? You wouldn't do that as a prosecutor.
A colossal mistake. I believe that all they needed to do was to build their case piece by piece. It's circumstantial. Don't put a cause of death before the jury. Tell them 30 days elapsed. There's an overwhelming smell in the car, chloroform in the trunk, insects in the trunk, duct tape. Give them the pieces to add it all together, put it together for them on summation, and give them the case. Don't give them an out.
All right, Joey, what about that? Wouldn't you as a prosecutor be better off? I mean, you spent years as a prosecutor. Wouldn't you try to use the duct tape to say, wait a minute, I'm not trying to demonstrate suffocation. I'm telling you that it makes no sense to put duct tape on a child who's already dead. Thus, the defense of an accidental drowning makes no sense.
Well, that's a good point, but I could see where they're going. Look, here's what they're trying to do. This is a capital case. They want to determine premeditation. They want to establish that the mother is a murderer. Now, how are they going to do that? They're going to do that exactly as they attempted to do. They're going to show that videotape. They're going to show where the duct tape was relative to this little girl's nose and her mouth, and they are therefore going to try to establish that the mother put the duct tape, there was chloroform there, she got her unconscious, and she killed her that way. But so I could see the reasoning behind them doing it.
You never make a promise that you can't fulfill.
That's the trouble. No, you never do. But they're going, look, the prosecution is laying out everything in this case, and they're putting it before the jury, and ultimately you hope that the jurors are intelligent enough to accept it.
All right, let's talk about what happened yesterday. Dr. Neil Haskell, who is essentially an expert on insects, and I think we have video of that. He said, look, based on the evidence, it is absolutely clear to me that Kaylee's body was hidden in the trunk of Casey Anthony's car for several days. And other evidence shows that she had custody of the car, drove it around for several days before the body was removed. I mean, that's pretty incriminating, isn't it, Vikki?
I think it is very strong, as well as the fact that a 9-inch piece of hair was found that was probably post-mortem. There was testimony regarding the fact that it was probably from somebody that had already died. The chloroform also, on top of all of the evidence, so strong, the odor so pungent, so long after. I think all of those things, the computer forensic to me was mind-blowing. 84 searches for chloroform months before this child was apparently missing.
All right. Lots more to talk about. We're going to pause, take a quick break, and we'll be right back with our legal panel to talk about why. Take a look at this. Controversy in the courtroom. The judge in the Casey Anthony trial allowing prosecutors show, well, controversial pieces of evidence. A photo, take a look at this, of Casey and Kaylee Anthony with a photo of the young girl's skull superimposed over her face, then an image of the duct tape superimposed over the mouth. Well, defense attorney Jose Baez seemed to be outraged. He repeatedly called for a mistrial because of this. If Casey Anthony is found guilty, could this help her win an appeal? With us again, our legal panel, Vikki Ziegler, Robert Schultz, and Joey Jackson. So, Robert, look, if the prejudicial effect outweighs any probative value, it could be, arguably, reversible error. What do you think?
It could be. Do I think it is? No, but I think a point that I would make is, was it necessary evidence for the prosecution?
It wasn't.
Did they have to put this type of evidence before the jury?
Right.
I say they didn't, because they're now creating an appellate issue for a defendant that, if there is a conviction, could throw their conviction into the air.
You know, Joey, I want to play a piece from Thursday. Casey Anthony is crying in court, and it was an incredibly emotional day because jurors were looking at these gruesome photographs of Kaylee Anthony's remains, and the defendant then begins wailing in the courtroom. I mean, she is crying so hard she becomes ill. She had to be escorted out of the courtroom. How does that impact the jury? Does that create sympathy for her?
You know what, Greg? Under normal circumstances, in a normal trial, I would say it absolutely does, because jurors are people, and any one of us on this panel could relate to someone who's lost their child. But in this instance, Greg, I don't think so, and here's why. You're dealing with already a case where they laid out, the prosecution that is, fact upon fact that she lied about, that she fabricated, that she basically this fiction. And so I think there's a significant trust issue that the jury doesn't trust her. They don't know what to believe. They think that she's just out there. Yeah. And as a result of that, I don't think it helps at all. It's another part of the act, according to them.
All right. I want to play a clip here. This is from the opening statement of the defense attorney, Jose Baez. And, you know, he makes a big deal about the man who discovered the body of little Kaylee. His name is Roy Kronk. He is a meter reader. And the defense attorney made a pretty outrageous claim that Kronk tampered with the body. Take a look.
Mr. Kronk is a morally bankrupt individual who actually took Kaylee's body and hid her.
Now, Vikki, is that the kind of thing that could create reasonable doubt? On the other hand, if he doesn't prove it, my goodness.
And he can't prove it. We know that. Just because somebody happened to be at a location, a meter reader, and has a poor past, that doesn't mean they're on a conspiracy regarding this murder or had anything to do with it. I think it's ridiculous. It's almost as saying the dog somehow in this case had they were conspiratorial. It doesn't make sense. Most of Jose Baez's opening did not make sense. And that's the question. He can't prove most of it, but they don't have the burden. The prosecution does.
Robert, is that the kind of wild accusation, if unproven, could really anger the jurors toward the defense?
Absolutely. As Vikki said, the defense has no burden of proof. And by getting in front of the jury and making accusations and telling them this is what you're going to learn, you're going to hear this, that almost shifts the burden to the defense, and that is another appealable issue that Mr. Baez has created for his client, an ineffective assistance of counsel claim.
Look, there was a computer expert, Joey, who took the witness stand this week. He testified that somebody searched the internet in the Anthony home on the computer for phrases like neck-breaking, shovel, household weapons, and 84 searches. It's unbelievable. Well, for chloroform, or how to make chloroform.
Here's the problem, Greg. That, of course, is damaging, but how you deal with it as a defense attorney is significant, and I don't think it was dealt with properly. I'm certain that there were significant other searches on that computer having nothing to do with chloroform. Those searches were in short duration, without question. There were only a few of them over a couple of days. All of these things needed to be highlighted to the jury so that you can create doubt. It should have been made a so what issue. It was not, and that's going to be damaging.
And you know what struck me? Tests performed on the tissue and the hair of the victim show no evidence of chloroform. So it's a mystery, and you know what mysteries do? They create reasonable doubt. Vikki Ziegler, Joey Jackson, Robert Schultz, good to see you. Thank you.
Pleasure, Greg.
Heather?